I now invite the judges of the Grand Chamber wishing to do so to put their questions to the parties. Judge Ravarani.
Thank you very much. One very short and easy question to the applicants. I don't know whether they want to respond to it. Is it the applicant's position that he used or that he didn't use bylog? Thank you very much.
Thank you. Judge Yüksel.
Very much related, similar question, because from also to the applicant, but of course if the government wants to comment, they can wish to do, if they wish to do so. But from my understanding of the observations in the submissions, there is a fact which is contested by both parties. So the applicant denies that he has ever downloaded or used bylog, and then the government contests this. So in this case file, the following submissions have been adduced regarding the use of bylog. So the finding of the assize court, based on reports obtained from relevant authorities, that the applicant had used the application on his GSM line from October 3rd, 2015 onwards. The finding of the expert report on the HTS and CG0 data requested by the Regional Court of Appeal that showed the applicant had connected to the server 380 times over 6 dates. So taking all into this account, as Judge Ravarani, I wonder the view of the applicant. So I'm just trying to understand if the applicant is suggesting that this court should set aside these findings. So thank you.
Thank you very much, Judge Yüksel. Judge Derinovic.
Thank you. I have a question for both parties. Would you please clarify the way the applicant obtained the bylog on his mobile phone? Was it by downloading or in some other way? If you could clarify this issue. Thank you.
Thank you. Judge Semachkova. Microphone.
I have a question to the representative of the government, if they can comment arguments about the lack of independency of justice and of the court deciding about the case of the applicant. Thank you.
I look to the judges to see if there are any further questions. If not, the court will now withdraw for 20 minutes, reconvening at 10:50, following which the parties will be able to submit brief observations in reply to each other's submissions and also in reply to the questions posed by the judges. Thank you very much.
La Cour.
Please be seated. The hearing is resumed. I draw your attention also to the fact that the judges will have the possibility, after hearing the answers to your questions, to ask for additional clarifications concerning those answers if they see fit, without, however, asking new questions. I give the floor to the government.
Thank you, Madam President, members of the court. We have heard a rather fact-based presentation by counsel opposite. The government generally objects to the facts presented. We do not have the time to point out all the misleading statements. I just want to highlight one. Counsel opposite, for example, claimed that the BILOG application had been downloaded 600,000 times. This is grossly misleading. The reports have established, and even reports accepted by the applicant, that there are just 215,092 user IDs, and that about 100,000 persons used the application. So speaking of about 600,000 creates a wrong image. I would invite the court to consult especially the decisions of the Turkish courts, where the facts are laid out. And I would also like to draw your particular attention to the minutes of the hearings of the Assize Court and the Ankara Regional Court of Appeal, because in these minutes you will also find decisions of the court you will not find in the final judgment, decisions with regard to procedure. You will also find in these minutes expressly recorded that the applicant has been reminded, for example, and I quote from the minutes of the hearing on 9th October 2017 before the Ankara Regional Court of Appeal, that the applicant may request collection of the concrete evidence to clear himself from suspicion, that he is provided with a possibility to remove the causes of existing doubts against him, that he may raise the points which are in his favor, and that he has a right to request more time to prepare a written defense. The applicant has not availed himself of these opportunities because his main line of defense was that he did not use BILOG. For that reason, at the time, he did not engage properly with the BILOG evidence. The applicant's counsel also raised the question of the authenticity and accuracy of the data. Again, if you turn to the decisions of the court, you'll find that the courts expressly dealt with the question of the reliability of electronic data in general and the authenticity and accuracy of the BILOG data. So the question was before the courts considered it, and the courts considered the BILOG data at the time reliable. I now turn to the questions by the honorable judges. Judge Drenjinovic asked how BILOG was obtained by the applicant. The simple answer is the government does not know. Not just in the case of the applicant, in none of the uses. BILOG can be acquired either by way of downloading the application from an application marketplace, like an app store. It could be transferred via Bluetooth. You could install it using a memory stick, or you could transfer the relevant data via a personal computer. So there are various ways. There is, however, one way to find out, at least with regard to one of these options, namely downloading it from the App Store if you have the mobile phone to which it was downloaded. Now, the applicant did not cooperate with the judicial authorities and did not hand over his mobile phone. So it could not be detected of whether he downloaded the application from an app store or whether he got it by other means. With regard to Judge Simakova's question regarding the lack of independence of the judiciary, we've heard a lot of general statements by counsel opposite, general accusations of pressure, of structural deficits, of vulnerability of judges that have been dismissed. Counsel opposite spoke, and I quote, of the independence of the judiciary in Turkey in general. But this is not a case about the judiciary in Turkey in general. It is, if I may quote Article 6 of the Convention, it is about an independent and impartial tribunal, namely the Second Assize Court in Kayseri and the Regional Court of Appeal in Ankara, the relevant chamber there, and the relevant chamber of the Court of Cassation. When I was going through the documents, I was struck by the fact that nowhere in the documents I could find the names of the judges involved unless I was looking at the decisions itself. So there was never ever any accusation of partiality or non-independence against an individual judge involved in these cases. So again, I would refer you to our earlier submissions that this is not about the judiciary in general, it is about these judges specifically. If you were to rule on the basis of the allegations made by counsel opposite, then all Turkish courts would no longer be considered impartial and independent. Every single Turkish court decision could be challenged before this court on the basis of the statements made by counsel opposite. That surely cannot be the case. I thank the court for its kind attention.
Thank you. I give the floor to the applicant's representatives.
Madam President, honorable members of the court, dear judges Derincinovic, Yüksel and Ravarani, I thank you for your questions. To briefly answer that question, the position of the applicant is that he did not download the BILOG application or not use the BILOG application. And therefore we claim three things. One, that the reports and documents that your Honorable Judge Yüksel referred to, that they are fabricated. Two, at least they are internally conflicting. And that is what I was explaining in my pleading, is that the documents submitted before the domestic courts state that applicant had his alleged criminal communications in October 2015, while the documents now submitted to your court, Annex 27, on the very last page, you will see that the only criminal communication that they allege the applicant has made dates from the 20th of June 2015. So a totally different time period. And so that is the point that we have made. The third point is that the only way for the applicant to show that he did not download the BILOG application would have been to access the original BILOG data. And then it would have been clear. Either there is a reliable chain of custody and one can clearly see that he is the one who downloaded the application or not. The government, even up till today, does not seem to know how the applicant would have done so. And that opportunity the applicant did not get. And that is so manifest that we do not ask your court to be a fourth instance, but that this concerns really general principles under Article 6 and 8 of the Convention. Perhaps a few short things I want to say in reply to the statements of the government regarding the users of the BILOG application. I just refer you to Annex 40, page 46 of the documents submitted by the government themselves, in which reference is made to an MIT technical report stating that there were more than 513,000 users of the BILOG application. So I don't think we have said anything that was not correct in that point. And lastly, as to the authenticity of the data, the government states that this authenticity was verified by the courts, but I wonder, how can a court verify the authenticity of data if even today they are not able to say whether the applicant downloaded or how he downloaded the data? The judges, the domestic judges, did not have access to any information that allowed to verify or say something credible with regards to the authenticity of the alleged BILOG data the applicant has used. I will now briefly pass the floor to my colleague with regards to the points on the independence. Thank you.
If ever that would be a misunderstanding, but I don't think it is, I was not pleading the lack of independence of the Turkish judiciary. That I have not been saying that, and I have not been pleading that. But I was pleading that the judges deciding in the Yalçınkaya case, specifically I was more oriented what the Court of Cassation and the Assize Court were not in the possibility to decide in an independent way, because the court they are member of was cleansed. 140 of the members of the Court of Cassation, the 16th chamber that decided on the case of Assize, 7 of 18 were replaced, 7 on 18. That's not a general element, that is a factual element. And knowing that, all this could happen in a context where unilateral, without contradiction, judges could be dismissed, which in reality happened, and that even no real appeal to the Council of State was possible, these judges in this specific context, knowing also that in the Court of Cassation the rules have changed, with the President having a discretionary power even during deliberations to change the composition of the panel, it's made that a normal human being as a judge was not free from fear. A judge who has to be afraid of what could happen without contradiction, without appeal, a judge who has a fear from what could happen can never be considered by the accused and also not by an objective observer to be independent. That was the basic element, and that has nothing to do with the judiciary in globally, which I was not pleading about.
Thank you very much. We've now come to the end of the hearing. I thank the parties for their submissions and for their answers to the judge's questions. The court will now deliberate on the admissibility and the merits. The judgment will be delivered later, and the parties will be informed of the delivery date. I declare the hearing closed.